Welcome to the Legal Broadcast Network. Former Ohio Attorney General Jim Petro and his wife Nancy have released a new book this past year about wrongful convictions and the injustice of imprisoning the innocent. The book, titled False Justice, 8 Myths That Convict the Innocent, explains how wrongful convictions can be prevented and challenges myths of the criminal justice system. Jim and Nancy, what a pleasure. Thanks for joining us today.
It is a pleasure for us to be with you. Thank you so much.
Thank you, Scott. Our pleasure.
Jim has said that these are sort of his accounts, and Nancy, you kind of got the prose together for this work. Why did you both decide to write this?
Actually, I don't think I actually decided. I was awakened in the night, honestly, with the notion that we really had to write down what we had experienced and learned regarding wrongful criminal conviction, which of course came as a surprise to both of us.
Yeah, in reality, I was minding my own business as Attorney General when I began to encounter multiple cases, but one very significant case in particular, where I was really shocked that people could be wrongfully convicted, incarcerated for 7, 8, 10, 13 years. I mean, variety of cases that arose, and be totally innocent, actually innocent of the crime, as proved then subsequently by DNA. And I began recognizing at least actions on the part of police and prosecutors that I felt helped to contribute to these convictions.
And if you look at the Innocence Project, which is a group that we cover frequently, there's been so many exonerations. I think a total of 250 in this country alone. One recently, Michael Morton in Texas, was in prison for some, I think, 20, 25 years. Allegedly, he was convicted of killing his wife, despite the fact that there was profound evidence and testimony proving that he did not do it. And it sort of brings things to mind the way the criminal justice system works. In this particular case, you have DAs who are elected and judges who are elected. That doesn't seem to be a good recipe for success a lot of the time.
Well, and the story in Michael Morton is remarkable and heartbreaking at the same time. You know, there was probably the most egregious Brady violation, and lawyers will understand what that means. That's the prosecution failing to turn over evidence that can, demonstrate the possible, at least arguably, the possible innocence of the defendant. And the evidence was extraordinarily significant, and they never turned it over. Subsequently, of course, after a 6-year battle to get DNA testing of a scarf that was probably 100 feet from the home, they did, and it showed blood from the deceased victim, who was the wife of Michael Morton, mixed with blood of another individual who'd been convicted of another similar murder a few years after the murder of Mrs. Morton. I mean, the evidence is remarkable. The story is a perfect example of prosecutors gone wild, not living up to their ultimate responsibility of seeking justice. And that's where the mistakes come into play. When people don't do what is their sworn duty, you're going to have tragedy arise.
You know, there was an argument not to test the bandana in this case because it was not exactly at the scene of the crime. And then when it was tested, after 6 years of attempts to have the right to test it, as Jim said, it had the blood of the victim and a known felon.
Right.
The tragedy of it was that DNA then also linked to a hair found at a murder of a similar, young mother of a young child in that region that happened subsequently. So had we gotten that one right the first time, that young mother would still be alive, the second one. And I think that's what has, in part, brought so much focus to the fact that very significant evidence was then discovered that had never seen the light of day to the defense.
One of the beautiful things about this book is it does address many of the myths that the average person has about the criminal justice system, because we sit here and we watch TV shows, and we watch the Casey Anthony trial, and we watch all kinds of documentaries on these things, and all of these myths that you bring up are things that at one time or another I thought, and I'm going to allow you to attack each one of these as we go down, because I think all of them are extremely interesting, and I'll start, and either one of you jump in whenever you feel like it, but The first myth was that everyone in prison claims innocence, which is something we hear all the time in real life and in movies.
And it really isn't that way. I argued in favor of, in the legislature, during my first year as Attorney General of Ohio, I, along with my senior criminal justice staff, began advocating for post-conviction DNA testing. Others in law enforcement thought we were crazy, but basically I look at this job as a search for the truth. And obviously DNA is a great truth resolver. And so we wanted to see where DNA could be an issue in a matter and a person was convicted. Post-conviction, they could go to court and they could petition for DNA testing. Law enforcement across the board basically argued against it. They said that, everybody in prison says they're innocent. We've got 50,000 inmates in Ohio prisons. You're going to have tens of thousands of petitions. We'll never be able to catch up. In the first 4 years, there were 313 petitions, and only 14 got testing. Sometimes, there was overwhelming delays, but the point that I make is not everybody claimed innocence. Certainly there wasn't DNA available in every case. But prisoners understood, and in some cases the prisoners who claimed testing and had then confirmed their guilt grew to understand that when they went to the parole board and that was kind of laying in their record, that was not going to help them at all. And so the trend that might have grown up where a few more might have sought DNA testing went away. And really only those people who consistently had been pleading that they were innocent were the ones who ultimately sought testing.
It makes one wonder, before the onset of DNA testing, how many people were wrongfully convicted. And it seems logical to me that in many cases, if the option is available, that would be the first thing one would do. I mean, and why doesn't that happen? Well, and
it does more and more now. We will see. Now, understand that only is DNA available in about 10% of the crimes.
Okay.
There are crimes where there's really not DNA available. In murders, there are often instances where DNA or blood stains or things like that can be left at the scene, as it relates also to things like fingerprints. In sexual assault cases, usually bodily fluids will be left, on the victim in most cases, and then if the victim is able to identify a perpetrator, the ability to match that DNA in the bodily fluid really comes from having custody of the perpetrator at that point, which is an interesting point, because beginning in 1990 or thereabouts, with DNA really coming onto the scene, the FBI began to keep lab records where these matches occurred, matches from bodily fluids taken from the victim that contained male DNA that was unknown. It was not, the victim's friend or anything like that. It was unknown male DNA. And then they matched that against the DNA taken from the individual that was a stranger to the victim but identified by the victim through an eyewitness identification procedure, a lineup or a photo array. And in 19,000 cases over nearly 20 years, 25% didn't match. Now, what that tells you is that for the years before DNA, if we relied on eyewitness identification, which is the least reliable form of evidence, I believe, but if we're relying on that, and it has an enormous impact on a jury, if you've got a victim on the witness stand pointing at the person at the defense table saying that's the person who committed the crime, they are going to get a guilty verdict. That's just how it is. But it underscores the problem where before DNA, where that occurred, those people would have been convicted. That's over 4,500 people that I'm describing here in that sample of 19,000 lab reports, where 25% didn't match the DNA. The victim had picked the wrong perpetrator.
Right.
And so that kind of underscores how deep the problem can be, especially in cases where the principal evidence, the only evidence in most cases, is eyewitness identification.